Guys, the United States Supreme Court has accepted a Second Amendment case. It's on a huge topic that I've been talking about forever, which is that in over 20% of the country, 5 states comprising over 20% of the citizens, the government is now making choices for you, about you, and your private property. We're talking about homes, offices, restaurants, places of work, business, shops, you name it. You've got to opt in to the Constitution and the Second Amendment now in those states. And you're a fool if you don't think that more states will adopt that and jump on that train. I'm so optimistic that the Supreme Court's going to be crushing this. So guys, let's get into it. So folks, briefly up front, the stakes are enormous. If the Supreme Court upholds these laws, the Second Amendment could become a hollow promise for tens of millions of Americans. We're talking about 20% of the country right now across the 5 different states that we're going to talk about that are being affected. But if you think that this type of gun control is limited to those 5 states, I don't know what you've been paying attention to. This particular gun law is the one that I've been going on and on and on about for years now, talking about how this is going to be a big threat and we need to hit this. And this is the reason why I'm very, very happy that the Supreme Court is accepting this. What we're talking about is the fact that the governments in 5 states have decreed that they can set a no guns as the default position on private property. In other words, if you are a shopkeeper, if you are an office owner, if you're a whatever, and if you want to have someone be able to lawfully possess and carry a firearm into your place of business or your home, your office, your whatever, you have to give them express authorization to do so. Otherwise, they are breaking the law. By setting the no guns as the default, the state is exercising a power it does not wield against any other constitutional right, a right that cannot be exercised anywhere but the open street is hardly a right at all. Whether the justices recognize and reverse this shift will signal how much and to whom the Bill of Rights still matters. That said, I'm very bullish on this. I do think we're going to get the outcome that we want. What's going on here? So across Hawaii, California, Maryland, New Jersey, and New York, 5 states that are not friends of the Second Amendment, lawmakers have made it illegal to carry firearms on private property unless the owner gives, as I mentioned, express authorization. This is a sharp break from the way that nearly every other right is exercised in public spaces, as well as private property, by the way. Nowhere else in American law are citizens required to seek formal approval in the form of this express authorization before exercising First Amendment rights. No state forces you to get explicit consent before wearing a religious symbol, a political t-shirt, or carrying a sacred text in your arms, or maybe as an app on your phone before you go into a restaurant, a shop, or an office. Yet for the Second Amendment, these 5 states have flipped the presumption and created a, let's just be honest, a near blanket ban on the ability of law-abiding citizens who the Supreme Court has recognized have a right to go armed in public. The state has basically made it impossible to do that. And they're doing it in the name of protecting private property rights. The controversy reached the Supreme Court, who accepted this case for review coming out of Hawaii, Wolford versus Lopez. Wolford's the good guys, Lopez, not so much. That's, for our purposes here, that's the Attorney General of Hawaii. The Supreme Court agreed to hear this case on Friday, October 3rd, after a federal court in Hawaii sided with the gun owners against the state and halted enforcement of Hawaii's law, only to see that decision maybe predictably reversed by the Ninth Circuit Court of Appeals. The appeals court wrote at the time, quote, "Nothing in the text of the Second Amendment or otherwise suggests that a private property owner, even owners who open their private property to the public, must allow persons who bear arms to enter." But as critics, that's me, point out, this framing, it's a gaslight. It's gaslighting the public. It's gaslighting the courts and what we're talking about here. No one is talking about forcing private property owners to have people carry firearms on their property. That is a complete fabrication and straw manning of what's going on here. The issue is not whether private property owners have the right to say no to guns. Of course they do. No, the key issue is whether the government has the right to make that decision for you, for me, and then people have to opt out of that decision by posting these express authorization signs. This isn't a question of defending private property rights. This is a question of whether or not the government can make those private property decisions for the property owners. Period. Full stop. That's what this is about. Is the government allowed to make this decision for people? Because everyone can still post the no guns here, all that kind of stuff. That's on the table. There's nothing, that's where we start. And the government's just saying, nah, we're banning it everywhere, unless someone wants to opt into the Constitution. Is the Constitution an opt-in clause? Now, the significance of this case has drawn an unusually direct intervention from the federal government. In a pretty rare move, the Trump administration filed what's called a friend of the court brief. In other words, not a direct participant in the case, but they're filing a, hey, this is what our position is, this is what we think you should do. They filed a friend of the court brief urging the Supreme Court to take the case even without being asked. The brief, which is 29 pages, I linked below. If people want me to go through this and make another video about just the brief, let me know. I'd be happy to do so. But the super low resolution broad strokes is they say, look, these 5 states comprise more than 1/5 of the nation's population. Inevitably, there's more states on the way. And let's just face it, this nullifies New York Rifle State Pistol Association versus Brune. This nullifies what the Supreme Court has said. This nullifies the Second Amendment when it talks about every American's right to go out and be protected. Again, there's a lot more to that. I'll go into it in another video if people want. Now, crucially, the court's review, in other words, what they're accepting, is just going to focus narrowly on one particular point: the constitutionality of these new private property default rules, or the opt-in to the Second Amendment rules. And you have to understand that when you're talking about cases going to the United States Supreme Court, there's often multiple different issues and sub-issues within them. But the Supreme Court maybe doesn't want to deal with issues 2 through 10. They only want to deal with issue number 1. And that's what we have here. The justices are not examining some broader questions that are part of this case about what places will qualify as sensitive locations. Hawaii banned, I believe off the top of my head, possession of firearms at any places where alcohol is served, for instance, declaring that it's a sensitive location. They did the same thing for parks and all that kind of stuff too. Sensitive location. Or what is the evolving framework for assessing whether a law fits within the history and tradition standard? Or put another way, when the Supreme Court said that a firearm regulation or law, in order to be found constitutional, needs to have some sort of analog, their word, not mine. They needs to have some sort of history and tradition behind it, generally speaking from a long time ago, not 1990s, probably not even 1900s. We're probably somewhere into the 1800s. Great. Where's that line? Is that Civil War and back? Is that 1890s? The reason why that's so important is because a lot of gun laws came on the books around the 1870s and forwards, especially as you go into the 1880s, 1890s. So if the Supreme Court says, look, Civil War and back, that's okay, we're in a very different pro-2A friendly home field advantage looking at cases for the indefinite future. If we're talking about, 1890s, 1880s, 1870s, that's all good. That's going to be a problem. Not as bad if we're talking about, for instance, 1910s and forward, but that's not great. So all those issues were part of this case. The parties asked to have them heard. They're not going into that. They're only going into whether or not the government has the right to make decisions for your property unless you opt out. Guys, as I already mentioned, I have been asking for this exact issue. As somebody who religiously conceal carries, I've been asking for this exact issue to be out there for so long now. Hitting the Supreme Court, predicted this years ago now, and I'm very excited that this is here and finally happening because I think we're going to have a great outcome on this. I'm disappointed we didn't get to some of those other questions that the Supreme Court will be looking at, but hopeful that we will at some point in the future. But for right now, this just tastes like victory. I think we're gonna have a great outcome. That's fantastic. I'm looking forward to it. Let me know if you want any follow-up on this. Obviously, I'm gonna be following the case as it goes along. We're gonna have oral arguments this winter. We're gonna have a decision sometime late spring to summer. So that's kind of the timeline for where this is gonna be going. But let me know if there's any specific follow-up, like on the briefs. Be happy to take a look at that. Drop your comments down below. Join the discussion. Don't be silent. Join the discussion. Hit that like button. Share the video. A quote of the day in honor of my shirt. I didn't feel like changing in my button down today. Let me know what you think about that. Okay, so this is just what I was wearing. Our quote of the day comes from none other than the George Washington, the first president of the United States, General of the Continental Army, who said, "If freedom of speech is taken away, then dumb and silent we may be led, like sheep to the slaughter." I wonder what he would have said about the Second Amendment. Too bad they all took it for granted back then. Otherwise, maybe we'd have some more ink spilled on it. I'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.